Hello. Tonight we're talking about how a civil trial works. In a criminal case, the government is trying to convict a defendant of a crime. In a civil case, one party is suing another, usually for damages in the form of money. Trials of civil cases are rare these days. Our panelists are experienced civil trial lawyers here in Minnesota, here to talk about the mechanics of a civil jury trial and answer your questions about the process. Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson, a partner at Falsani, Balmer, Peterson, and Balmer, and this evening's moderator. I'm pleased to welcome our panelists. First, Bob Falsani, my partner. Next, Jim Balmer, also my partner. And then finally, Sara Nachtman, an attorney at the Thibodeau, Johnson, Feriancek firm here in Duluth also. We're ready for your questions. Call locally at 218-788-2844, or if it's long distance, please call toll-free at 1-877-307-8762. Okay, so the introduction that we had raised 2 points we want to get out of the way right away. First of all, civil versus criminal. I know, Bob, years ago you did some criminal defense work. So just in a nutshell, what's the difference between a criminal case and a civil case?
Well, usually the criminal case, somebody's got a really good chance of going to jail, and in a civil case, that is not the case. So now, criminal case, you might have fines, and that could, certain criminal cases involve really high fines. Some of these business things, you know, where you're polluting or whatever, it might be a criminal case for polluting, and you might have huge fines. Civil case for polluting might have huge fines too. But that's really the central thing, that one is the state against people saying, okay, you did something wrong, we want to put you in jail or have a criminal penalty. And the other is usually private parties that are suing each other, although sometimes you're suing the government or government suing you or whatever in a civil case.
And the two parts that we have to prove in a civil case, liability and damages versus guilt, right?
Yes.
So when you're the lawyer in a case, how do you look at things differently in that context?
Well, the huge difference is when you have a criminal case, you're trying to get a not guilty when you're a private lawyer, and if you're a prosecutor, trying to get a guilty. But sometimes the presentation is very similar, except for oftentimes in a civil case, you're dealing with damages where you're not in a criminal case.
So go ahead.
Well, there's something that I think that the viewers need to know, and that's that in a criminal case, the state is the plaintiff. The prosecutors are not prosecuting the case for the benefit of the victim or the victim's family. This is something that's being done by the state of Minnesota for the benefit of the public safety, to maintain public order. Whereas in a civil case, the case is brought by a private lawyer like one of us for the benefit of the people that hired us to prosecute the claim for compensation. And I think Sarah's got another difference that she wanted to mention. Did you want to talk
you can
about
keep going.
You're trying to trick her. You're tricking her. Yeah.
Well, she had mentioned before we went on the air that there's a difference in the burden of proof.
Okay, that was going to be my next question. So we hear a lot about burden of proof and reasonable doubt and that sort of thing. Sarah, what's the difference between civil and criminal and with respect to that?
Sure. So in criminal law, you have to be guilty beyond a reasonable doubt. And the way that I've heard that described is you have to be as sure as you would want to be about getting married to somebody. You need to be very, very sure. And in a civil case, the burden of proof is more likely than not. So pretty sure, but definitely a lower standard.
They say 51%.
Right.
And then plaintiffs' lawyers like us, we use the hands for the, right?
Yes, right. The scales of justice.
Tip the balance even ever so slightly, then that's sufficient to meet the burden.
You know, and that's one of the big things when you represent plaintiffs in a civil case, is to make sure the jury's not trying to use a really high standard of proof, because a lot of times in the civil case it's kind of gray. You know, it's like, okay, who went over the center line or whatever in a head-on collision case? And it's like, you know, we're not quite sure 100% here who probably went over the center line. And then, you know, it's who's more likely to have gone over the center line kind of thing.
Or is it more likely than not that the plaintiff suffered a permanent injury?
Right, sure.
Okay. The second thing we talked about in the introduction is the relative scarcity of civil jury trials. And Jim, why is that?
Well, before I tell you why I think that's the case, I can give you some statistics. We at our office today went through the most recent statistics for the Minnesota courts. In the federal courts, in the 2 years, 2016, 2017, less than 3 out of 100 civil cases went all the way to verdict. In the Minnesota state courts, statewide, there were over 1.2 million cases filed in 2017. These are civil disputes. And, well, no, that was all kinds, including criminal, family, juvenile. And of those 1.25 million cases, only 30,500 were major civil cases, the kind we're talking about here. And the only other statistic I'll give you that you'll find interesting is here in northeast Minnesota, there were 46,600 filings in 2017 of all kinds, of whom only 1,700 were civil cases. So the number of cases that are civil cases is actually less than 5% of the total filings. Now, the number of cases that actually go to trial in the United States, civil cases in 2017, it dropped from 6.5% 15 years ago to only 4.5%. And the average settlement amount received by the people making claims has dropped by 42% over that same time span. Nobody's sure why this is. Some people say it's because of the increase in the number of private mediations. Some people think it's because, and I tend to agree with this, that juries are less likely to award compensation to people, so lawyers are less willing to take the cases and less willing to take them to trial when they do take them. But there may be other opinions on either side of me.
Well, the gap there between the cases filed and the cases that go to trial obviously is cases that get settled.
Right.
Or maybe dismissed, but mostly settled, right? So Sara, you mostly represent insurers, defendants in these cases. Why, from your perspective, do most cases settle rather than take your chances in front of a jury?
Well, I think that on the one hand, doing a jury trial is terrifically expensive and time-consuming, and in a civil case, there's usually 6 jurors, potentially 2 alternates, and for somebody to put their whole life in the hands of 6 to 8 people, I mean, there's just a tremendous risk there, and I think that's why when you get to mediation or these other alternative dispute resolution processes, there's just a temptation to settle and know you're getting something versus take that big risk.
I think the 2 things that I've noticed in my practice that I'd say have had a huge effect, and one is the tremendous cost of trials in terms of expenses. You know, in an injury case, for example, the cost of expert testimony and so forth. It's just ridiculous. For, you know, if you've got a smaller case, you know, you can spend $10,000 trying a case where you're expecting a verdict of $25,000. Well, a lot of lawyers won't spend the money, and their clients can't afford it. And then the other big factor is the amount of effort the court system has done to push us into getting cases settled. And mediation in every single case is basically almost mandatory. And the lawyers have gotten accustomed to that, and it's almost like your trial is your mediation sometimes. You better damn well prepare well for the mediation if you expect a good result in the case, because you might be able to settle the case fairly early, save a lot of money, and put more money in your client's pocket.
Okay. Yeah, I mean, the cost of, I looked into having somebody do a video reconstruction of a surveillance video, and it was going to cost like $50,000, and just to find out if there's really a good case there, you know? Right. Geez. Okay. So I want to run by a couple of terms that that folks may have heard that One of them is jury nullification, okay? We hear about that, and I think there's a John Grisham book or 10 in which, you know, that's one of the themes is, and we hear it in a criminal case like O.J. Simpson, right, where the jury's not going to convict him, maybe despite the facts. So does that work in a civil case as well?
Oh, yes. Jurors these days are increasingly skeptical of the validity or good faith of a plaintiff who brings a claim for injury. And even though the evidence almost requires a finding of liability and damages, the jury will frequently return zero. I had a case I tried in December. It was a liquor liability case. Jurors, at least in this part of Minnesota, don't like those cases. So even though the evidence we had was little short of overwhelming, the jury returned a verdict of no liability. They don't like holding bars responsible for illegal service of alcohol, and they are not going to do it.
Yeah, that is the classic. And there's been a run of horrendous cases, you know, blood alcohol, you know, 3.35, you know.
Well, in this one, the blood alcohol was 0.33.
Yeah.
And they decided that the guy wasn't obviously drunk.
Yeah, I mean, unless there's a videotape and the guy's puking on his shoe and then they're giving him 3 more martinis, I mean, they're just not going to find liability.
Right, that's the kind of case where you're, the lawyer is trying to sue the bar or the liquor establishment for the fault of the, say, drunk driver. And
Well, it's
juries
the fault
don't,
of the bar getting the drunk driver drunk
right,
and
but
serving
juries
him.
don't like it because they say, why didn't you sue the drunk driver? And you
Yeah.
say, well, because
He
he
has
didn't have
no-
any insurance because he's a drunk driver, right?
Yeah. Yeah.
Flip side of that, Sarah, John Grisham again, runaway jury, okay? Jury looks at the facts and says, you know what, we're not just going to award, you know, $100,000 to this injured person. We're going to give him $28 million, okay? I know it's rare around here, but do you see that in your practice where jury just gives away the farm way more than you would have thought?
Well, I think there's always that risk if you have somebody that is hurt a little, maybe not hurt so much, but is just a terrifically likable, sympathetic person that sometimes, you know, contrary to what you're talking about, you'll get that opposite effect of a very large damages award where maybe somebody that wasn't as likable with a similar injury would have had a different result.
Yeah, I had this cheerleader one time, and she got injured when she was about 17, and she was beautiful and smart and charming, and you know, and she had a bad spinal injury that was non-surgical, but the jury went crazy. They just loved her so much. I thought they was going to carry her out of the courtroom at the end of the case. It was amazing, you know. So
let's talk about another topic that we struggle with explaining to our clients all the time on both sides, which is the rules of evidence and what you can say and what you can't say. And the first thing that always comes up, Bob, why can't we talk about the insurance?
because there's a rule that says you can't. But you can in Wisconsin because Wisconsin allows it. So that's nice. That's one of I call these, when I'm picking a jury, I always kind of say there's going to be some things you're not going to know here. And that's kind of my tip off to the jury. They're not going to know about the insurance. But I say, and I always call it, the hidden kind of things, and the jury's always, what's going on here, so. Yeah.
Well, and it's not just the insurance that the defendant might have, but you can't talk about other insurance. You can't. There's all kinds of things. Why is that? Do we know the root of these rules?
Yeah, that most of the rules of evidence are thought to prevent unfair prejudice or bias creeping into the case. Typical juror has a tendency, and we all do, I do this personally when I'm not a lawyer, to want to find out what your past is, who you've hurt in the past similarly, do you have a criminal record, and they tend to want to try you for who you are, not what happened in this particular case. So these rules are all intended to prevent that from happening so that the jury is forced to consider only the facts in the case. And there's other rules that admonish the jury against using Google during the trial, using Facebook, to keep them from poking around and doing their own research. And the whole point of these rules is to confine the evidence to what the jury sees and hears in the courtroom, so that the judge has control over that.
Sarah, don't you think jurors know that anyway, though? I mean, don't they figure that, you know, your client, for example, has insurance and that somebody must have paid all these medical bills? They aren't just sitting out there waiting to be paid?
Sure, and I mean, in my trials, I usually assume that most of the jurors have an understanding of how, you know, car insurance works, for one example. But then I also assume that they're thinking about, wait, wouldn't they get some money from their health insurance? You know, I assume that that's in the back of their mind too. And I think with respect to just the evidence stuff, I think a lot of jurors, you can't cover 5 years of medical treatment in a 3-day trial or a 4-day trial. So a lot of jurors will look for shortcuts, and I think that falls right into, you know, maybe we should pop on Facebook, or we should do something to figure out if you're a criminal, or if we can like you, or if we can believe you, just because those are easier shortcuts than reading, you know, a stack of medical records that high.
Don't you assume that the jury's going to look up everybody in the room on Facebook as soon as that day of the court is over?
I don't. I'm
really
very naive.
Well, I can tell you that in the last 10 years, although Facebook didn't come up, but in the last 10 years, I've had 4 cases involving allegations of juror misconduct. I did not have any in the previous 35 years of trying cases.
And was
None.
it all social media related?
No, they weren't, but they were things like the jurors deciding to ignore judges' instructions, people allegedly approaching the jurors during the trial to talk to them about how the case should turn out, those sorts of things. And we had to have Schwartz hearings, and which is a hearing intended to get at the facts of what's behind the jury problem and so on. But it wasn't a problem until relatively recently, in my experience.
We have a question from a viewer here. Why is the opposing, I'm just going to read it, why is the opposing counsel allowed to badger a witness? Which kind of gets into the role of the lawyer and the judge in kind of controlling the trial.
Right, and you know, judges are a gamut of personalities, and you have some judges that run a really tight ship, and there's not going to be any badgering, and the lawyer is acting up, they'll come down hard on him, and the lawyer's going to pay for being a jerk, you know. And other judges are more laid back, and lawyers sometimes get away with murder. So, you know, I'm not
Not literally.
No,
No.
no, but I'm not naming names either,
No,
by the
no,
way.
I know-
All
I
you
know what
wonderful
you-
judges out there, I'm
Yeah,
not
yeah.
naming your name. Okay?
Well, and
Yeah.
I mean, would you agree it can kind of backfire too? I mean, if you're being nasty, jurors don't like lawyers being nasty to people unless you're, you know, Adolf Eichmann on the stand, right?
Yeah, right.
You know.
Although some people just get away with it because it's their personality and it's not a false thing. They probably mean to their wives too, but, you know, or their husbands. But, you know, it's just some people can be a lot more brash, and the jury doesn't get as irritated. And I don't know why that is, but it's true. Don't you think?
Well, yeah, I agree. Yeah, it depends on how tight the judge calls the balls and strikes. But the point is that when the opposing lawyer is cross-examining a witness, the purpose of the cross-examination is to test the truth of the witness's story. And to some extent, a judge is going to allow the lawyer to ask those difficult to answer questions, or the questions that make a witness uncomfortable. That's the nature of cross-examination, and it's part of every trial. And I agree with everything Bob said, that sometimes people go overboard, and sometimes the judge pulls them back, and sometimes the judge doesn't. So.
Yeah, no, I would agree with that. I think cross-exam should be uncomfortable, but then there's a point where if the lawyer is getting too hot, that draws attention away from the good information that you're trying to get out on cross-exam, so it can be counterproductive.
This is where the personality of the parties is really important. You know, you have, I mean, some people are just likable and charming and obviously very honest, and then when somebody tries to take them on and they go overboard, that will backfire in a hurry. You know, on the other hand, you got somebody that's a little bit sleazy or kind of a liar or not very forthright, and they can be pretty nasty to that person, so, and get away with it.
Yeah, and you can make a snide remark like, I don't know why you're being so nasty, Brian. We're just trying to get the truth out here. Right? I don't know where we were in the line here. Jim, here's a question from a caller. What are the odds of people actually collecting on a favorable verdict?
In almost all the cases that we handle, and I'm referring to all three of us, the person who loses the case, assuming there's a favorable verdict for the injured person, has insurance. And typically, the insurer will pay the judgment so that there's a complete collection. Now, occasionally, that does not happen. But even then, frequently, the defendant has enough assets to satisfy the claim. You had a successful verdict against an uninsured defendant, and he paid the verdict in full, if I recall, a few years ago, and it was a substantial verdict you obtained.
Well, I think his wife made him, but...
Well, regardless, he still paid up.
Well, I had that sexual abuse case last year that I resolved, and you know, the guy paid some money. I mean, he paid a substantial amount of money, and now the case might have been worth 5 times that or 10 times that, but
he didn't have the money to pay.
There was no insurance. Yeah. There was no insurance there, and it was it was one of those kinds of things.
Sarah, here's a question that gets back to the idea of settlement, and this is a little bit different for you. The question is, what do you do when your client wants to go to trial and you think the case should settle? And it's a little bit different in your case because you've got the insurance company, and then you might have an individual who insists on their rights when the insurance company is saying, look, let's just cut our losses and go here.
Yeah, that question gets a little technical with respect to knowing who your client is, but as a general matter, I think you need to know who your client is and work for them. And
your client is?
Your client.
It's a little vague there.
Well, Bob, what do you do when you and your client don't exactly have the same idea about whether to go forward with the trial or settle?
Well, fortunately, through the years, I haven't had too many clients that didn't listen to me. Because let's face it, I've got a lot of experience and I've been there. But every once in a while you get a client that thinks they're smarter than you are, and most of the time that's not very good in the end. I mean, you're leaving money on the table what you shouldn't be leaving, and most of the time you're going to get burned. You evaluate the case and you kind of know where you're going. Client won't play ball, and for their own benefit, it's bad. So it's very frustrating, isn't it?
Yeah.
Yeah.
Yeah, but if all else fails, you will try the case. That's what you were hired to do. And if the client won't take the settlement, you try the case and make sure they understand the risks. And if they lose, as they usually do, and in that setting, a loss is defined as getting less than was offered. You might still get a verdict, but if you get less than the other side was willing to pay to settle the case, that ain't a victory.
No, but you might get shut out too.
Yeah, frequently you get zeroed.
The people on our side of the fence, I mean, we're on that bucking bronco when the client says, let's go, we're not going to settle this thing, and you're saying, well, we shouldn't be trying this case, and then you take it to trial. I mean, you don't know how it's going to end up, and a lot of times you end up on the ground. So it isn't pretty. And nowadays, insurance companies, and Sara knows this, you lose a case against an insurance company, they tax the cost against the client, and the client has to pay the out-of-pocket costs of the insurance company, including the outrageous amounts of money they pay for their doctors that testify for them.
One of the problems that brings this on is when you discover too late that your client was listening to somebody you didn't even know was there. And it's somebody who lacks legal training, lacks a comprehensive understanding of what the case is about. It's a well-intentioned relative, a well-intentioned friend, and they are your client, for some reason, is listening to that person instead of the legal advisor that he hired and is paying money to for legal advice. So
my best one is clients complaining, saying, geez, is that all we're going to settle for, and blah, blah, blah. My buddy had the same exact case, and he got 3 times as much money. And I said, well, what's your buddy's name? And he'd tell me the name, and I said, you go and hire that guy's lawyer, because I was the lawyer, and it's not the same case.
Not bad.
Yeah.
We have time for one quick question. We've been talking about a jury trial. Do you have the option of waiving a jury and having a judge decide what the jury normally would?
Both sides do. But in my experience, when the plaintiff, that's who I almost always represent, waives a jury, the defendant demands one. And then you'll have a jury, like it or not.
So either side has the right to a jury.
Yes.
And with a few exceptions, I suppose, but we're not.
Right.
Like
We're not going to
injury
get
case.
into that.
But that would, divorce court you don't
Equity
have.
jurisdiction.
There's lots of other kinds of cases where you can't have a jury. Workers' comp, you have a judge. Divorce court, you have a judge. So there are certain kinds of things where you're never going to have a jury.
And sexual harassment cases, you didn't have a jury, and now you do all of a sudden. Right.
Well,
Okay. Well, thanks a lot. That was a really good talk. That's all the time we have. It went by really fast, as usual. Thank you for watching. Remember, you can find all of this season's shows on Lawyers on the Line on the WDSE website. I'm Jim Peterson. Have a great summer. Good night. See you next year.